Hi everyone and welcome to my CISSP video series. In this video series, we will be diving deep into the CISSP exam preparation, breaking down the key concepts and providing in-depth explanation of the questions and answers. I am a cybersecurity professional having about 15 years of experience in the field. I have obtained over a dozen international certifications including the CISSP, CCSP and CISA. I am glad to share my knowledge and experience with you guys through these videos. In today's videos, we will be tackling about 50 questions from Domain 1 of the CISSP exam, Security and Risk Management. So grab your notes and let's break down these questions to help you on your CISSP journey. Don't forget to like, subscribe and hit that notification bell for more content like this. So let's get started. Question number 1. Ethan is preparing a report for management summarizing the findings of his latest risk assessment. He wants to highlight the level of risk that persists within organization even after implementing the security controls. Which term accurately describes this remaining risk? So we are talking about the remaining risk after implementing the security controls, and what is the term that is used for this remaining risk. And we have the options: option A, control risk; option B, mitigated risk; option C, residual risk; and option D, inherent risk. So if you want to think about it and answer the question, you can pause the video and then answer it first yourself and then unpause the video to see the answer. I will go to the correct answer, and the correct answer is the option C, residual risk. So when you implement the security control, remember that you cannot 100% remove or mitigate the risk. There will always be some quantity or some percentage of risk remaining even after implementing the security control, and that remaining risk is known as residual risk. The mitigated risk is the risk that is reduced or is mitigated. Inherent risk is the risk before implementing the security controls. So these are the two important terms. The inherent risk is before implementing the control, before implementing the security control, while after you implement the control, then the remaining risk is known as the residual risk. The control risk is the risk associated with the security control. So each security control has also a inherent risk within the control, such as if you implement the firewall and you do not implement the firewall as per the standard, as per the manual, or as per the required configuration, then again, although you have implemented the firewall, you have installed the firewall, it may not be working as desired and as required. So this is the control risk. And this is the explanation. So the residual risk is the remaining risk after implementing security controls. Inherent risk is the original risk before any control, while control risk is the new risk introduced by control themselves. Mitigated risk is the risk that has been reduced by existing controls. I hope this is clear. Let's move forward to the next question. Question number 2 is that Lily has conducted a qualitative risk assessment for her organization and recommends purchasing cyber security breach insurance. Which risk response strategy is she proposing? And the options are: option A, transfer; option B, reduce; option C, reject; and option D, accept. So when you purchase insurance to transfer your losses during a security breach, then, as I use the word transfer, this type of risk mitigation or risk response strategy is known as the transfer. So the correct answer is the risk transfer. The reduce is basically the risk mitigation. When you implement the control, then this strategy is known as the risk mitigation, and you reduce the risk in that strategy. Except is when you accept the level of risk because your control or implementing the control are way costlier than the risk itself. Risk is not a viable strategy. It's just something like burying your head in the sand without doing anything. So you cannot just reject the risk. You have to do either transfer it, either reduced it, or either if the risk level is low, you have to accept it. So again, this is the explanation. Purchasing insurance is a method of transferring risk. If Lily had focused on reducing the likelihood of a cybersecurity breach, she would have been implementing a risk mitigation strategy. Continuing operations without changes would be an example of risk acceptance. Rejecting the risk is entirely is not a viable strategy even if it happens unintentionally. Let's move forward to question number 3. Alan, a security specialist for a US-based online service provider, has received a copyright infringement claim. A third party alleges that a user is storing copyrighted material on the service. Which law governs Alan's actions in response to this claim? So, publishing the copyright material on your online website. So this is infringement of the copyright material. So which law governs this type of situation? And the options are: option A, Digital Millennium Copyright Act; option B, Lanham Act; option C, Gramm-Leach-Bliley Act; and option D, Copyright Act. And the correct option is underlined. It is option A, the Digital Millennium Copyright Act. So remember the word digital, since we are talking about publishing the copyright material online or digitally. So it is dealt with by the Digital Millennium Copyright Act. So the explanation: the Digital Millennium Copyright Act, that is DMCA, outlines the responsibilities of online service providers when dealing with copyright infringement claims. The Copyright Act establishes the framework for obtaining and protecting copyrights but does not address the actions of online service providers. The Lanham Act governs trademarks, while the Gramm-Leach-Bliley Act regulates the handling of personal financial information. So this point is also important. The GLBA Act, it handles the security of personal financial information. Question number 4. A cyber security professional is responsible for maintaining an effective security awareness program. To ensure the program remains relevant in the face of evolving technology, what control can they implement to prevent content obsolescence? And the options are: option A, live training; option B, content reviews; option C, gamification; and option D, computer-based training. And remember, whenever you are answering the question, and you will always be given 4 options. So always look for the option that is a more generic, or an option that contains a full answer and that contains the answer of other options as well. Let's suppose in this case, if we look at the option B, content review. So if you review the overall content, it means you are also looking into the training types, the technology that should be used in delivering the training, and the content, which is the most important factor, the content of the training itself. So the correct answer is the content review. So to mitigate the risk of outdated content in the security awareness program, The cybersecurity professional should implement a regular content review process. This involves periodically assessing whether the program's material align with the organization's current needs and address emerging security threats. While various training methods like computer-based training, live sessions, and gamification can enhance the effectiveness of the program, they do not inherently guarantee content accuracy. A dedicated review mechanism is essential to ensure the program remains up to date and relevant. Question number, sorry, this should be numbered as 5. So this is question number 5. Fly Now Travel operates in both the EU and the US and regularly transfers personal data between the two regions. An EU customer has requested the deletion of their account according to the GDPR, General Data Protection Regulation, which principle mandates that individuals have the right to request the erasure or deletion of their personal data. So, and the GDPR is basically an EU privacy regulation or policy. It deals with the privacy of the PII or personally identifiable information. So there is, you can say, a section or there is you can say a point in this regulation that gives the customer or the user this ability to ask their service providers for deletion of their personal data if it is no longer used or no longer needed. So what is that principle? And the options are: option A, the right to be forgotten; option B, privacy by design; option C, the right to data portability; and option D, the right to access. And the correct option is the right to be forgotten. So this is the most famous part of the GDPR. And the right to be forgotten or the right to erasure allows individual to request the deletion of their personal data. This right is often linked to consent. If an individual withdraws their consent for data processing, the data controller may be obliged to erase their data. Question number 6. Which of the following elements of information is generally not considered personally identifiable information under most US data breach laws? So we are talking about PII, that is personally identifiable information. So, which of these is not a PII? So, 3 are PII and one option is not related to PII. And the options are: option A, credit card number; option B, driver's license number; option C, social security number; and option D, student identification number. And the correct option is student identification number. So, these three are basically PII. They are regarded as personally identifiable information, while student identification number is not a PII information. So many state data breach notification laws are based on California's law, which covers specific types of personal information like social security numbers, driver license numbers, credit card numbers, and bank account numbers. California's law also protects medical records and health insurance information, which are not always covered in other states. These data breach laws are different from privacy laws by the CCPA, which has a broader scope for regulating personal information handling. Question number 7. EVA is addressing her board of directors about their obligations regarding cybersecurity controls. Which principle mandates that senior executives personally account for information security matters? And the options are: option A, due process rule; option B, prudent man rule; option C, personal liability rule; and option D, due diligence rule. And the correct option is the option B, prudent man rule. So the explanation is that the prudent men rule hold senior executives accountable for exercising the same level of care that a reasonable person would in similar circumstances do. Initially used in finance, this rule was extended to information security matters in the US in 1991 through the Federal Sentencing Guidelines. Question number 8. Ethan is working with the European Union business partner to facilitate the exchange of customer information. So always remember, look for the key points and keywords inside the question so that you can answer the question accurately. Ethan's organization is based in the United States. What would be the most effective method for Ethan to ensure GDPR compliance? So Ethan organization is in the US, while a business partner is in the European Union, where GDPR is applied. So how Ethan will comply to the GDPR while living in US or inside the US? And the options are option A, standard contractual clauses, option B, binding corporate rules, option C, privacy shields, and option D, safe harbor. And the correct option is the standard contractual clauses. So remember that the privacy shields and the safe harbors, these were basically the laws between the EU and US to govern the transfer of data between EU and US, but these laws were basically suspended or made null and void by the EU courts. I don't remember the exact name of the court, but they were suspended by the EU, so they are no longer applicable. So now the data transfer between EU and US is governed by the standard contractual clauses. So this is the explanation. The European Union offers standard contractual clauses for companies to use when transferring data. This is the best option for two separate companies sharing data. If the data is being shared within the same company, binding corporate rules can also be used. So remember, this is for data sharing within the same company, and this is for data sharing between different companies. If the data is being shared with the EU-US Privacy Shield, a former safe harbor agreement is no longer valid for data transfer, as I already explained. And let's move forward to question number 9. Daniel is the chief privacy officer for a financial institution and is researching privacy regulations pertaining to customer checking accounts. Which of the following laws is most likely applicable in this scenario? And the options are option A, SOX, option B, HIPAA, option C, FERPA, and option D, GLBA, that is Graham-Leach-Bliley Act. We just studied this law a while ago, and I told you to remember this because this law is very important and will be used. You may come across question in your actual CISSP exam, and you should remember that GLBA deals with the financial data privacy of the individual. So the financial data is the accounts, bank data, and so on. So the correct answer is GLBA, Graham-Leach-Bliley Act. So the Graham-Leach-Bliley Act includes regulation for protecting the customer financial information. It applies specifically to financial institutions. The Sarbanes-Oxley Act, that is SOX Act, governs financial reporting for publicly trading companies. The Health Insurance Portability and Accountability Act, that is HIPAA, regulates the handling of protected health information, that is PHI. The Family Education Rights and Privacy Act, that is FERPA, governs the handling of student educational records. So there is a slightly different between GLBA and SOX. Both deals with the financial data, but the SOX deals with the financial transaction and data of the publicly trading companies, such as the stock exchange data, and it regulates the publicly trading company for their transparency and their financial records, while GLBS specifically deals with the customer financial data. HIPAA, again, it deals with the medical records and medical data of the patients, while the FERPA is basically deal with the educational data. Question number 10. Smith's organization recently secured a government contract for sponsored research. Which law is likely applicable to the information systems involved in this contract? And the options are option A, PCI DSS, Payment Card Industry Data Security Standard, option B, HIPAA, option C, GESRA, and option D, FISMA. So remember, the keywords are the government contract and the information system, and we are talking about the law that applies to the information system that is contracted for the government or as such, and the correct option is the FISMA, Federal Information Security Management Act. So the Federal Information Security Management Act, FISMA, specifically applies to government contractors. The Government Information Security Reform Act, that is GISRA, a predecessor of FISMA, expired in November 2002. HIPAA and PCI DSS regulates healthcare and credit card information, respectively. Question number 11. Sarah is advising travelers from her organization who will be visiting various countries overseas. She is concerned about compliance with export control laws. Which of the following technologies is most likely to trigger these regulations? And the options are option A, encryption software, option B, hard drives, option C, office productivity applications, and option D, memory chips. So which of these is most likely to be a controlled item that may trigger the export regulations? And the correct option is the encryption algorithms or encryption software. So the export of encryption software to certain countries is subject to US export control regulations. Memory chips, office productivity applications, and hard drives are generally not covered by these regulations. Question number 12. Sarah is investigating a security incident and discovered that an attacker started with a normal user account but managed to exploit system vulnerability to gain administrative rights. What type of attack occurred according to the Stride threat model? So, if you look at the question, we are talking about the user started with a normal account and then it elevated this normal account to the administrator privileges or administrative privileges. So, this type of action is known as elevation of privileges, and this E in Stride stands for elevation of privileges. So the options are option A, repudiation, option B, tampering, option C, spoofing, and option D, elevation of privileges. And the correct option is option D, elevation of privileges. So in an elevation of privilege attack, an attacker transforms a limited user account into one with higher privileges, allowing them to access more of the system. Spoofing attack involves falsely representing one's identity, while repudiation attempts to deny responsibility for an action. Tampering attacks aim to modify or damage information or resources. Question number 13. You are finalizing your business continuity plan and have decided to accept a certain risk. What should be your next step? So the key points are that during business continuity plan, You look for the all type of risk and you have decided to accept a certain risk. So what should you do? You should do next. And the options are: option A, develop a disaster recovery plan. Option B, document your decision making process. Option C, implement new security control to reduce the risk level. And option D, repeat the business impact assessment. So the key point here is, right after accepting the risk, what should you do? Sorry, you should document your decision making process as to why you accepted a certain risk. So when accepting a risk, it's essential to document the decision making process to meet future audit requirements. This should be done before implementing security control, designing a disaster recovery plan, or repeating the business impact analysis. Question number 14. Eva is developing a business continuity plan and is struggling to prioritize resources due to the difficulty of combining tangible and intangible assets information. What risk assessment approach would be most effective in this situation? And the options are: option A, quantitative risk assessment; option B, qualitative risk assessment; option C, neither quantitative nor qualitative risk assessment; and option D, combination of quantitative and qualitative risk assessment. So we are talking about two type of assets information: tangible and intangible. So the quantitative basically deals with the tangible assets information. It is also known as the risk that can be measured in dollars, while the qualitative risk deals with the intangible assets information. This is a type of risk which you cannot measure in dollar form, but you can make your mind, or you can measure the risk in terms of medium, low, or high. And this is used for intangible assets. So since Eva is dealing with both the tangible and intangible assets, therefore she should combine the quantitative as well as qualitative risk assessment. So that's why the correct answer is option D, combination of qualitative and quantitative risk assessment. By combining quantitative and qualitative risk assessment, Eva can achieve the best results. Quantitative risk assessment is effective for financial risk analysis, while qualitative risk assessment is well suited for intangible risks. Combining these techniques provides a comprehensive understanding of the risks involved. Question number 15. Richard suspects a former employee stole trade secrets and shared them with a competitor. Under which law could he file charges? And the options are: option A, Glass-Steagall Act; option B, Lanham Act; option C, Economic Espionage Act; and option D, Copyright Act. And the correct option is option C, Economic Espionage Act. So the Economic Espionage Act imposes fines and imprisonment for those convicted of stealing trade secrets from US corporation, providing strong protection for intellectual property rights. Copyright law is not applicable in this case, and there is no evidence of copyright infringement. The Lanham Act deals with trademark protection, and the Glass-Steagall Act was a banking reform law irrelevant to this situation. Question number 16 is that which principle sets a broad standard of care for individuals similar to what one would expect from a reasonable person in the same situation? And the options are: option A, due care; option B, separation of duties; option C, due diligence; and option D, least privilege. And the correct option is option A, Due care. So the due care principle basically requires individual to act with reasonable care in a given situation, similar to what would be expected of any prudent person. It's a broad standard. Due diligence, a more specific component of the due care, mandates that individuals assigned responsibility exercise reasonable care to complete those tasks accurately and timely. Question number 17. Megan's organization recently acquired a competitor. So we are talking about a merger. Which task is least likely to be addressed during the acquisition process? And the options are option A, documentation of security policies, option B, protection of intellectual property, option C, integration of security controls, and option D, consolidation of security functions. So what happens during acquisition? Sorry, here we are talking about what is least likely or what does not happen during acquisition or merger. And the correct option is the protection of intellectual property. So you need to protect your intellectual property if an organization splits into two. While here we are talking about two organization, one organization acquiring another or a merger of two organizations. So you don't need any type of protection of intellectual property. And the explanation is that intellectual property protection is a more significant concern during divestitures, where a subsidiary is spun off into a separate organization. Acquisition, on the other hand, typically focus on consolidating security functions and policies as well as integrating security controls. Question number 18. Grace suspects an employee is using company resources for personal gain. After consulting with management, she decides to launch an administrative investigation. What is the standard of proof she must meet in this investigation? And the options are option A, beyond a reasonable doubt, option B, preponderance of the evidence, option C, beyond the shadow of doubt, and option D, there is no standard. So if we look at the option A, beyond a reasonable doubt, this is basically used in the criminal cases. So here we are not talking about criminal cases. The preponderance of evidence, it is used in the civil cases. Beyond the shadow of doubt, it is also beyond the reasonable doubt. So our answer is basically that there is no standard for administrative investigation. So although there is no specific legal standard for internal administrative investigation, it's advisable for organizations to establish their own internal standard or standard of proof. This helps maintain consistency, fairness, and thoroughness in the investigation process. Question number 19. Acme Systems recently developed a new microprocessor manufacturing process. They want to license it to others but prevent unauthorized use. Which type of intellectual property protection is most suitable? And the options are option A, trademark, option B, patent, option C, copyright, and option D, trade secret. And the correct option is option B, patent. So both patent and trade secrets can protect intellectual property related to manufacturing processes. However, trade secrets are suitable only when the information can be kept confidential within the organization. In this case, a patent is the most appropriate option. Copyrights are used to protect creative works, and trademarks protect names, logos, and symbols. Question number 20. Which of the following actions might be included in a business continuity plan? And the options are option A, relocating to a cold site. Option B, restoring from backup tapes. Option C, implementing RAID. RAID is redundant array of independent disks. And option D, restarting business operations. And the correct option is we can implement the RAID during the business continuity plan, because RAID technology provides fault tolerance for hard drive failures and is a business continuity measure. Restoring from backup tapes, relocating to a cold site, and restarting business operations are disaster recovery actions. Question number 21. After identifying assets in business impact analysis, what's the next step? And the options are: option A, determine the risk facing each asset. Option B, develop a value for each asset. Option C, identify vulnerabilities in each asset. And option D, identify threats facing each asset. And the correct option is option B, develop a value for each asset. So after identifying assets in a business impact analysis, the next step is to assign values to each asset. The other activities listed occur after asset valuation. Question number 22. Mike implemented an intrusion prevention system to block common network attacks. Which risk management strategy is he using? And so remember, we talked about implementing a security control, and when you implement a security control, it means you are mitigating the risk. So here we have the options. Option A, risk acceptance. Option B, risk avoidance. Option C, risk transference. And option D, risk mitigation. So since we are implementing a security control to mitigate the risk, so this strategy is basically risk mitigation. Risk transference is when you transfer the risk to a third party, such as when you buy insurance. So this is the type of risk transference. Risk acceptance is when the risk level is low and you do not implement any security control and accept the risk as it is. Risk avoidance is when you altogether leave the activity with which the risk is associated. So let me get the explanation. So risk mitigation strategies aim to lower the likelihood or impact of a risk. Intrusion prevention system reduce the probability of a successful attack, making them examples of risk mitigation. Risk acceptance involves consciously accepting a risk without further action. Risk avoidance modifies business activities to eliminate the risk, while risk transfer shifts the risk cost to another entity like an insurance company. Question number 23. David, a federal agent, is investigating a computer crime. He wants to bring charges against a suspected attacker. What standard of proof must he meet? And the options are: option A. So we are talking about the criminal charges or a crime. So what type of proof is required for criminal charges? And the options are: option A, preponderance of evidence. Option B, beyond the shadow of doubt. Option C, beyond a reasonable doubt. And option D, majority of the evidence. So for criminal cases, you must have a proof that is beyond a reasonable doubt, while this is for the civil cases where there are financial damages or punishment involved. But while in criminal cases there is jail time, or in rare cases death penalty are involved. That's why the burden of proof is beyond a reasonable doubt. So for criminal case leading to imprisonment, the prosecution must meet the beyond a reasonable doubt standard of proof. This is the highest legal standard and applies to all criminal cases. Question number 24. The International Business Machine, that is IBM, uses a specific logo. This is the logo. This is the IBM logo. Which type of intellectual property protection can they use to safeguard their rights to this logo? And the options are option A, copyright, option B, patent, option C, trade secret, and option D, trademark. And the correct option is the trademark. So the logos, icons, slogans, motto, etc., they are led by the trademark. So trademarks protect words and symbols used to represent a company, product, or service. Copyrights protects creative works, while patents and trade secrets are used to protect inventions and similar intellectual property. Question number 25. Sarah is assisting a computer user who is seeing a message on their screen. This is the message. What type of attack has likely occurred? So here we are talking about this message that has appeared on a user screen. It's talking about the encryption of user files, and this is a timer left, and the message reads to provide some ransom money for the key to decrypt your files, and you have this much time left. So what type of attack or this intrusion is? And the options are option A, disclosure. So here we are talking about what type of attack has likely occurred. And the options are option A, since the user has no longer access to to his or her files. So what type of attack is this? A, disclosure, B, availability, C, distributed, and D, confidentiality. And the correct option is availability, since the user can no longer access his or her file because they are encrypted. Therefore, this attack is a type of availability attack. Another popular type of availability attack is DOS or DDoS, when users are no longer able to access online services due to these type of distributed denial of distributed denial of services attacks. So the message is an example of a ransomware which encrypts a user's computer data to prevent access. This is a type of availability attack that disrupts system usage. There is no evidence of data disclosure or involvement of other systems in a distributed attack. Question number 26. Among the following organizations, which one might not be automatically subject to HIPAA's privacy and security requirements if they engage in electronic transactions? And the options are option A, Health Information Clearinghouse, option B, Health Insurance Plan, option C, Health and Fitness Application Developer, and option D, Healthcare Provider. And the correct option is the Health and Fitness Application Developer. So a health and fitness application developer might not be subject to HIPAA unless they collect or process protected health information. HIPAA primarily applies to healthcare providers, health information clearing houses, health insurance plans, and their business associates. Question number 27. Daniel's network is expecting slowness due to a flood of TCP SYN packets. He suspects a denial of service attack. Which principle of information security is being violated? So we are talking about a denial of service attack, as I talked about just in the a question or two questions ago. So what type of attack is launched through denial of service attack, and which principle of information security is violated through denial of service attack? And the options are option A, confidentiality, option B, integrity, option C, denial, and option D, availability. So again, the answer is availability. So since in denial of service attack, the user are no longer able to access their legitimate services. So a Smurf attack, so this attack, the TCP SYN attack is known as, flood of TCP SYN is known as Smurf attack. So the Smurf attack is a type of denial of service attack which jeopardizes the availability of a targeted network. It's a classic example of an attack that directly violates the availability principle. While Smurf attack don't directly target confidentiality or integrity, they can indirectly impact these principles if the system becomes so overwhelmed that data is lost or corrupted. However, the primary focus of a DOS attack and therefore the violated principle is availability. Question number 28. Rennie is developing a long-term security plan with a 3 to 5 years horizon, focusing on aligning security with overall business objectives. What type of plan is she creating? And the options are option A, operational, option B, tactical, option C, summary, and option D, strategic. And the correct option is option D, strategic. So the strategic plans have a long-term horizon, typically 3 to 5 years. They align the security function with overall business objectives. Operational and tactical plans have shorter time frames, usually a year or less, and focus on specific security measures and activities. Question number 29. Emma is developing a new product and wants to protect the company's logo. Which US government agency can best assist her with intellectual property protection for the logo? And the options are USPTO, I think it is the United States Patent and Trademark Office, option B, NIST, option C, Library of Congress, and option D, NSA. And the correct option is option A, USPTO. So for logo protection, a trademark is the appropriate intellectual property mechanism. Emma should contact the United States Patent and Trademark Office for trademark registration. The Library of Congress handles copyrights, while the National Security Agency and the National Institute of Standard and Technology are not involved in intellectual property protection. Question number 30. Acme Widgets is implementing a new control in its accounting department to prevent a rogue accountant from creating a false vendor and issuing fraudulent payments. Which security control would be most effective? And the options are option A, mandatory vacation, option B, separation of duties, option C, defense in depth, and option D, job rotation. And the correct option is separation of duties. And why is that? It is because separation of duties is the most effective control in this scenario. By dividing critical tasks among different individuals, it prevents a single person from having the necessary authority and access to commit fraud. Mandatory vacation and job rotation are designed to detect fraud, not prevent it. Defensive depth is a broader security strategy and might be considered later to add additional layers of protection. Question number 31. Among the following organizations, which is most likely subject to FISMA's privacy and security requirements? FISMA is Federal Information Security Management Act, and the options are option A, schools, Option B, banks. Option C, hospitals. And option D, defense contractors. So which one of these is subject to FISMA privacy and security requirements? And the correct option is defense contractors. So the Federal Information Security Management Act, that is FISMA, applies to federal government agencies and their contractors. Among the listed options, defense contractors are most likely to have government contracts that fall under FISMA's jurisdiction. Question number 32. Richard is responsible for securing systems that process credit card information. Which security control framework should he follow? And the options are option A, SOX, Sarbanes-Oxley, option B, HIPAA, option C, GLBA, and option D, PCI DSS. And the correct option is for credit card information, the security control framework to follow is PCI DSS, that is Payment Card Industry Data Security Standard. So the Payment Card Industry Data Security Standard, that is PCI DSS, governs the handling of credit card information. The Sarbanes-Oxley Act regulates financial reporting for publicly traded companies. The Health Insurance Portability and Accountability Act, HIPAA, protects protected health information, that is PHI, while the Graham-Leach-Bliley Act, GLBA, regulates the handling of personal financial information. Question number 33. Among the following roles, who is typically responsible for carrying out the operational data protection tasks delegated by the senior management, such as validating data integrity, testing backups, and managing security policies? And the options are option A, data custodian, option B, data owner, option C, user, and option D, auditor. So the validation of data integrity, testing of backups, and managing the security policies is carried out by option A, data custodian. So data custodians are responsible for implementing the security controls defined by the senior management and data owners. While data owners have ultimate responsibility, they often delegate operational tasks to data custodians. Question number 34. Richard's e-commerce company's content was stolen and republished without permission. Which type of intellectual property protection would best safeguard their rights? And the options are option A, copyright, option B, trade secret, option C, patent, and option D, trademark. And the correct option is option A, copyright. So copyright law protects written works like website content. Trade secrets are not suitable for publicly available information. Patent protects invention, while trademarks protect words and symbols. So here we are talking about someone stealing content from your e-commerce website and publishing it on their own website. So this is protected through copyright law. Question number 35. Sarah received a flyer from a US federal government agency announcing a new administrative law that will affect her business operations. Where can she find the full text of this law? In the options are option A, Supreme Court rulings, option B, United States Code, option C, Compendium of Laws, and option D, Code of Federal Regulations. And the correct option is Code of Federal Regulation, or CFR. So the Code of Federal Regulation, CFR, contains the text of all administrative laws promulgated by federal agencies. The United States Code contains criminal and civil law. Supreme Court rulings contain interpretation of law and are not laws themselves. The compendium of laws does not exist. Question number 36. Sophia enabled an application firewall to block common network attacks. From a risk management perspective, which metric is she trying to reduce? And the options are option A, RPO, option B, MTO, option C, likelihood, and option D, impact. So she are trying to prevent or reduce the likelihood of network attacks. So the correct option is option C, likelihood. So by installing an application firewall, Sophia is attempting to lower the likelihood of a successful attack. This is a risk mitigation strategy that focuses on reducing the probability of a risk occurring. Adding a firewall does not directly address the impact of a risk. The recovery point objective or the maximum tolerable outage. Question number 37. Among the following individuals, who would be most effective organizational owner for the information security program? And the options are option A, Chief Information Officer, that is CIO. Option B, Manager of Network Security. Option C, CISSP Certified Analyst. And option D, President and CEO. And the correct option is option A, Chief Information Officer. So while the owner of the information security program might differ from those implementing the control, this role should be held by a senior executive. The president and CEO might not have the time to focus on security. Among the remaining options, the Chief Information Officer is the most senior position and can effectively advocate for security at the executive level. Question number 38. Sarah is a senior manager on a business continuity planning team. What is her primary role? And the options are option A, arbitrating disputes about criticality. Option B, evaluating the legal environment. Option C, training staff. And option D, designing failure controls. And the correct option is option A, arbitrating the disputes about criticality. So senior managers play various roles in business continuity planning, including setting priorities, securing resources, and resolving disputes among team members. Question number 39. Williams' organization suffered a credit card data breach under PCI DSS, that is Payment Card Industry Data Security Standard. Which organization might investigate this matter? And the options are option A, bank, option B, PCI SSC, option C, FBI, and option D, local law enforcement. And the correct option is option A, bank. So PCI DSS is a standard set forth by the Payment Card Industry Security Standard Council. However, it's enforced through contractual relationships between merchants and their banks. In case of a breach, the bank would typically initiate an investigation under PCI DSS. Law enforcement agencies might also investigate if the circumstances warrant a criminal probe, but they do not have direct authority to enforce PCI DSS requirements. Question number 40. You are the CISO for a major hospital system and are about to sign a contract with a SaaS email vendor, that is software as a service email vendor, to assess their business continuity planning measures. Which type of audit should you request? And the options are option A, FISMA, FISMA is not a type of audit. Option B, SOC 1. Option C, PCI DSS. And option D, SOC 2. And the correct option is option D, SOC 2. So remember these two type of audit report, they are very important. And also remember and learn the difference between these two, SOC 1 and SOC 2. So the Service Organization Control SOC 2 audit program includes business continuity control, while FISMA and PCI DSS may also audit business continuity. They would not directly apply to an email service used by a hospital. SOC 2 is specifically designed to provide assurance about a service organization controls, including those related to business continuity. Question number 41. Thomas is investigating a security incident and encounters a user who denies performing an action that Thomas believes they did. According to the STRIDE threat model, what type of threat has occurred? Do you remember this? You must remember this STRIDE model. It is, I think, spoofing, tampering, repudiation. This E is evaluation of privileges. D is, I think, maybe denial of service. And I is, I think, information disclosure. I don't remember it at the top of my head, but you must remember this threat model. So what does when a person does something and he or she denies it, which what threat model, what type of threat has occurred according to the STRIDE threat model? And the options are option A, repudiation, option B, information disclosure, option C, tampering, and option D, elevation of privileges. So you will only be able to answer if you know the STRIDE threat model and this abbreviation or the meaning of each of these letters. So the correct option is option A, repudiation. So what does repudiation means? So repudiation threats allows, let me get back. The repudiation threat allows attackers to deny their actions without being proven otherwise. In this case, there is no evidence of information disclosure, tampering, or elevation of privilege. Question number 42. Sarah is security administrator for a public school district. She is implementing a new student information system and is testing the code to ensure that students cannot alter their own grades. So the keywords are altering their own grade or cannot alter their own grade. Which information security principle is she enforcing? And the options are option A, confidentiality, option B, availability, option C, integrity, and option D, denial. And the correct option is option C, integrity. So integrity deals with the correctness of information, and when you alter the information, it is no longer correct. So this principle of altering information is dealt with by the integrity. Integrity controls like the one Sarah is implementing are designed to prevent unauthorized modification of information. There is no evidence of attacks on availability or confidentiality. Denial is a goal of attackers, not security professionals, and is irrelevant in this context that focuses on protecting data integrity. Question number 43. Among the following, which issue is typically not addressed in a service level agreement, that is SLA? And the options are option A, maximum consecutive downtime, option B, uptime, option C, confidentiality of customer information, and option D, failover time. And the correct option is option C, confidentiality of customer information. So SLA typically don't address data confidentiality issues. Such provisions are often included in non-disclosure agreement, that is NDAs. Question number 44. Sarah developed a piece of software. Which type of intellectual property protection would not be applicable for this software? And the options are option A, trademark, option B, patent, option C, copyright, and option D, trade secret. And the correct option is option A, trademark. And why is that? So the trademark protect words and images associated with a product or service. They would not be suitable for protecting computer software. So we are talking about not applicable. Copyright, patent, and trade secrets are more appropriate option for software protection. So remember, you should expect questions regarding these intellectual property protection mechanism, including trademark, patent, copyright, and trade secret. You must know the difference, the meaning of each of these, and the difference between each of these, and what type of information is protected by these. Question number 45. Hannah is a human resources specialist preparing to terminate an employee. Which of the following is typically not part of the termination process? And the options are option A, signing an NCA, option B, account termination, option C, recovery of property, and option D, an exit interview. And the correct option is option A, signing an NCA. So non-compete or non-disclosure agreement are typically signed during the hiring process. Exit interviews, recovery of organizational property, and account termination are common steps in a termination process. During the exit interview, the team might review employment agreements, including NDA, to ensure ongoing compliance. Question number 46. Sarah is reviewing her organization's business continuity plan documentation. Which of the following is typically not included in such documentation? And the options are option A, statement of accounts, option B, statement of priorities, option C, statement of organizational responsibility, and option D, statement of importance. And the correct option is statement of accounts. And the explanation is that a well-structured business continuity plan typically includes continuity planning goals, statement of importance, statement of priorities, statement of organizational responsibility, statement of urgency and timing, risk assessment and mitigation documentation, vital records program, emergency response guidelines, and maintenance and testing documentation. It does not include the statements of accounts. Question number 47. An accounting employee at Doolittle Industries was recently arrested for embezzlement. The employee transferred money to a personal account and concealed it by moving funds between other accounts. Which control might have prevented this fraud? And the options are option A, separation of duties, option B, least privilege, option C, defense in depth, and option D, mandatory vacation. And the correct option is option D, mandatory vacation. So the mandatory vacation programs require that employees take continuous period of time off each year and revoke their system privileges during that time. The purpose of these required vacation periods is to disrupt any attempt to engage in the cover-up actions necessary to hide fraud and result in exposing the threat. Separation of duties, least privilege, and defense in depth controls all may help prevent the fraud in the first place, but are unlikely to speed the detection of fraud that has already occurred. Question number 48. Chris wants to use an industry standard approach to assess his organization's risk management processes. Which maturity model would be most suitable? And the options are option A CMM, option B SW-CMM, option C RMM, and option D COBIT. And the correct option is option C RMM. So what is RMM? So the risk maturity model RMM is specifically designed for assessing enterprise risk management programs, while the capability maturity model CMM is a general framework for process improvement. RMM is more tailored for risk management. The software capability maturity model, that is SW-CMM, focuses on software development processes. COBIT is a framework for IT governance and control, not a maturity model for risk management. Question number 49. John's organization recently experienced an attack that made their website inaccessible to customers for several hours. Which information security goal was primarily affected? And the options are option A denial, option B confidentiality, option C integrity, and option D availability. And since we are talking about the unavailability of the website or services, so this is an attack on, or this is the information security goal that affected is availability. So as we already studied, the DOS or DDoS attack is always against the availability of information. So denial of service and distributed denial of service attacks are designed to disrupt the availability of information system and networks by overwhelming them with excessive traffic or other malicious actions. Question number 50. Emma is writing a document that will specify the minimum security requirements for all systems in the organization. What type of documents is she preparing? And the options are option A procedure, option B guideline, option C baseline, and option D policy. And the correct option is option C baseline. So the baseline basically establishes the minimum security requirements that all systems must meet. This type of information would not be found in policies, guidelines, or procedures. Policies provide high-level guidance, guidelines offer recommendations, and procedure outlines step-by-step instruction. So that's all for domain 1. I will be soon uploading the video for other domains as well. So please like and subscribe for the upcoming video. Thank you and see you soon.